sure.
Oh my God, I thought there was going to be paper.
Oh, is this for us? That's sweet.
Chocolate?
I don't know, but apparently it's for us, so guess we'll find out afterwards. Yes, the ad law panel where
Is it okay?
tens of people must be interested in our...
Okay, thank you all for hanging in there. This is a great panel to follow up on this morning's panels. We originally intended it to be about major questions doctrine, but in prepping for the panel, we thought, oh man, there's a lot more to cover. So it's becoming a kind of a landscape of administrative law as of this summer. So today I have here Corbin Barthold, Director of Appellate Advocacy at TechFreedom, Harold Feld, Senior Vice President of Public Knowledge, Jonathan Nuechterlein, Partner at Sidley Austin, Jennifer Tatel, Partner at Wilkinson Barker Knauer, and I'm Sarah O'Lamb, Senior Fellow at the Technology Policy Institute. So in prepping for this panel, we thought, oh man, we're going to level set and have 3 to 5 minutes for each panelist to brief us on what's happening. And so we kind of divided it up. Jonathan Nuechterlein will talk about Loper-Bright. Corbin Barthold will talk about major questions doctrine. Jennifer Tatel on the Jarchezi decision, and Harold Feld on non-delegation doctrine. So I just want to hand it off and start with Jonathan.
Hi, thank you, Sarah. So my remit is to describe Chevron. Hi, Brian. Describe Chevron and Loper-Bright in 3 to 5 minutes. Hopefully I can do some justice to a very complicated area of administrative law. So when Loper-Bright was decided just a few weeks ago, you saw a lot of stories in the press about how the decision represented a sea change in administrative law. It was the Republican judiciary engaged in a power grab against the progressive federal government currently under Democratic leadership. And that is to be expected because obviously journalists want their stories to have bold headlines and to tell a powerful story, but it misses a lot of the nuance. And so I'm going to talk a little bit today about the nuances of administrative deference as I have perceived them over the years. So I joined the FTC's general counsel in 2013, and that was a great time to be a government lawyer because the Chevron doctrine had reached its apogee. Chevron, for the non-lawyers in the room, is or was the doctrine that provided that when there's a statutory ambiguity, a court's role is first to ask, is this a genuine ambiguity? And if it concludes that there is, to defer to any reasonable determination by the agency of what the statute means. So this is separate from agency fact-finding. Instead, agencies were given leeway to give the force of law to their interpretations of ambiguous statutes. And in 2013, the Supreme Court decided the logical extension of Chevron, which was in a case called City of Arlington. They concluded that an agency's interpretation of its own organic statute provisions regarding the agency's own scope of authority was also entitled to deference. That was a great time to join the federal government, particularly in a Democratic administration where we were, contrary to what you might hear in some of the populist press today, in fact, engaged in what we considered pushing the envelope. In some ways, we needed to push the envelope because in the second term of the Obama administration, Congress had begun to fall into dysfunction. It was clear that the president wasn't going to be able to enforce many of his priorities through legislative action. And so the general tenor of the second term of the Obama administration was that agencies should do what they could to construe ambiguities in statutes, to effectuate the Obama administration's policy visions. And to some extent, the courts were receptive to that. Sometimes you would get questions of your private sector opponents in oral argument along the lines of, does anything in this statute unambiguously preclude the agency from doing this thing that you have challenged? That was how Chevron was construed in its late years, as basically permission to agencies to be aggressive in their construction of their own authority and their construction of particular provisions to fulfill policy objectives unless Congress squarely foreclosed them. So this riled up the Supreme Court, particularly the separation of powers movement within largely the Republican bloc of the Supreme Court. You see a court alternating between formalism and pragmatism on a number of issues over the years, and it's safe to say that Chevron represented pragmatism. The court thought that the pendulum shifted too far in favor of pragmatism and imposed formalism, so separation of powers formalism. And that's what we get in Loper-Bright. So in that decision, the court basically said, statutes are for courts to interpret. This is what courts are good at. Agencies have no special expertise in interpreting statutory language. Courts are good at that. That's what we're going to do. We're no longer going to defer to agency interpretations of statutory language, even if they are ambiguous. But there are important loopholes, and this is where we get into the nuances that I mentioned at the beginning. One loophole is what's called Skidmore deference. So technically, it is no longer the case that a reviewing court has to defer to a reasonable interpretation of a statutory ambiguity. But that doesn't mean that courts will ignore what agencies think about the meaning of a statute. And so we have language in Loper-Bright preserving the principle that under Skidmore, courts may properly resort for guidance from the executive branch if they confront a statutory ambiguity, especially if the agency interpretation comes early, early in its application of a new statutory provision, and if the agency has been consistent over time. Now, in addition to that loophole, there's another really important one for congressional delegations of discretion to agencies, not just on factual issues, but also on little quasi-legal issues. So Congress sometimes tells agencies, you guys go out and determine what a just and reasonable rate is. And when Congress does that, the Supreme Court says that a court's role is to respect the congressional delegation of authority, maintain its proper boundaries under the non-delegation doctrine, and they didn't use the term defer, but what they meant was defer to agency interpretations of such delegations as long as the agency has reasonably explained how it's exercised its discretion. So, in a nutshell, I mean, my response to the Loper-Bright decision is to think, look, it's really important, but it's not quite as categorically momentous as you might think from reading the paper. So under the old Chevron regime, skeptical judges had leeway to reject agency interpretations of ambiguous statutes, and under the new Loper-Bright regime, permissive judges have leeway to accept, under the Skidmore doctrine or under the delegation principle, agency interpretations that could have gone either way. So what has changed? A lot of what's changed is just attitudinal, and I'm going to wrap up. A lot of what's changed is attitudinal. Basically, the Supreme Court was telling the lower court judges, do your job. Try harder to interpret the best meaning of a statute, and don't just reflexively defer to any agency interpretation. Be judges. The other important takeaway is that agency flip-flopping on the meaning of a statute will no longer be accepted. And we've seen some of that, particularly in industries represented by some of the people here, by agencies that basically decide that statutory provision means one thing under one presidential administration and another thing under a different presidential administration. We're not going to be able to see that anymore because of Loper-Bright. That's arguably a pretty healthy development.
Okay, moving to the next leg on the chair. 2022 marked the arrival of the major questions doctrine, either a new thing or just the first use of the label at the Supreme Court. Depends on who you ask. The main ruling is West Virginia versus EPA. The court struck down the EPA's Clean Power Plan, which attempted to impose, roughly speaking, a carbon cap and trade program on existing coal power plants. We've had other notable major questions cases recently. There was the CDC eviction moratorium case, the OSHA vaccine or test mandate case, and the student loan cancellation case. I am under brutal time constraints, so ask ChatGPT to summarize those for you if you need it. There are several potential major questions cases coming down the line. FCC digital discrimination, FCC Title II, the SEC climate disclosure rules, the SEC crypto litigation, the FTC non-compete ban. There's even a Federal Highway Administration case floating around. This remains a big topic. The doctrine we now have is that if an agency wants to resolve a major question, it needs clear authority to do so from Congress. So, what is a major question? We could cover a whole hour on that. It's something to do with questions of great political or economic significance. If you're dealing with an agency measure that Congress has considered and rejected in failed bills, you might have a major question. If the measure intrudes on state authority, that might get you there. But how politically contested, how economically significant, how rejected by Congress, how intrusive on the states, in what combination? There's a little guidance in the case law on these issues, but each one individually could generate much more. What I'd like to focus on are a few high-level, almost philosophical issues that surround major questions, things to think about as we keep seeing these cases. In West Virginia in particular, the Roberts majority, the Gorsuch concurrence, and the Kagan dissent grapple with issues of the first importance, including the imprecision and thus inherent contestability of language, the inscrutability of the popular will, the complexity of modern society, and the limits of expertise. They debate the role of the judiciary and of the administrative state in a country with a, let's just say, suboptimally functional legislature. They dispute the very nature of representative democracy and the vagaries of human governance. So these are issues at the core of liberalism, understood as a never-ending debate about irresolvable questions. So, 3 quick things. First, notice the stories that the competing sides here tell about Congress. Neither story is wrong, but neither is entirely compelling either. The majority in West Virginia treats Congress as this very responsible body that is eager to make all the major policy questions itself. In this story, Congress does not legislate mush using vague words that everyone can read their disparate aspirations into and then pass a big mess to agencies and courts to sort out. No, never. The dissent, meanwhile, treats Congress as this far-sighted body that, say, envisions in 1970 an EPA that with no further legislation will one day address, not just dirty air and acid rain, but carbon dioxide and global climate change and nationwide energy policy. Second point, we have a system right now that the political scientist Stephen Tellis refers to as a klujocracy. When Congress is not as active or as precise as some of us might hope, the other 2 branches start trying to prop up the system with gum and duct tape. So we get the executive branch trying to legislate with a pen and a phone. It digs through old legislation, looking for little statutory hooks on which it can hang major policy programs. Then we have the courts. You might think they are pushing back on executive overreach. Or you might think that they're stepping on the toes of the real experts on this stuff, who are not generalist judges, but the specialists in the agencies. I will say this much. I think it might be a bad idea for the judiciary to go to heroic lengths to restore the separation of powers, even if you agree that that's the project that they're undertaking. Third and final point, expertise versus politics. The line between those two is blurry, to put it mildly. We want agency experts doing expert stuff, crunching the data, doing cost-benefit analysis. We don't want experts doing pure politics. They're not supposed to strike out on their own without Congress's permission, making big value choices in areas where, as Aristotle said, certainty is impossible and opinions are divided. Major questions stands for the notion that under the separation of powers, the further you go down that line toward politics, the more that's supposed to be Congress stuff. If Congress is going to pass the buck, it at least needs to do so clearly. And maybe, in some cases, it can't do so at all. Non-delegation, dun dun dun, dramatic hamster. To close, though, and again, I think there are major questions, as it were, about how well equipped the courts are to police these lines.
So Jarkissi. Jarkissi is an enforcement case, so a little bit different from what Corbin and John have talked about. In Jarkissi, the Security and Exchange Commission brought claims against Mr. Jarkissi for violations of the security laws. The SEC statutes provide that the SEC can choose to adjudicate in-house with the ALJ or before the federal court. In Jarkissi, the SEC chose to adjudicate with the ALJ. The Supreme Court, in a 6-3 decision written by the Chief Justice, held that where the SEC seeks civil penalties for securities fraud, the defendant has a right to a jury trial, not the in-house adjudication by the ALJ. Chief Justice Roberts described this decision as a pretty straightforward application of the Seventh Amendment. Seventh Amendment provides that for suits at common law, there exists a right to jury trial. Suits in common law doesn't mean only suits that were at common law when the Seventh Amendment was ratified, it turns out. It includes any claim that is legal in nature. That includes the statutory securities fraud claim at issue in Jarkissi. The question really as to whether it is a suit at common law is whether the cause of action resembles a common law cause of action. So in Jarkissi, the securities fraud allegations under the Security and Exchange Act and the other SEC acts resembled common law fraud, and that made it a common law cause of action under the Seventh Amendment. The second question really is whether the remedy is the kind of remedy that's obtained at common law. So that means monetary penalty that's punitive or intended to deter, not injunctive relief or a remedy that's restitution in nature. The Chief Justice, in his opinion, focused on that second question, the remedy question, and called it all but dispositive in this case. The monetary penalty was $300,000, something in that range, and the court said that it was clearly intended to punish the alleged fraudulent activity. The court did spend some time on the close relationship between federal securities fraud and the common law cause of action of fraud. The concept is they target the same kinds of conduct. And he also focused on the fact that Congress uses the phrase fraud in the security laws, the idea that Congress may be intended to incorporate the common law concept of fraud into the securities law. So he found that there was a right to a jury trial for Mr. Jarkissi. The court did then go on to talk about one exception to the Seventh Amendment jury trial right, and that's the public rights exception. The public rights exception is historically focuses on matters that are traditionally assigned to the executive or the legislature and removes them from the Seventh Amendment jury trial right. So think of immigration law, customs law, tribal issues, the granting of public benefits. These are the types of things that prior decisions have found to be under the public rights exception. And then the analysis gets a little bit caught up in the case between the public rights exception and the common law cause of action. But the court basically says that fraud is not the type of cause of action that would normally be assigned to the executive or the legislature. It's a traditional common law judicial function, so the exception does not apply. That's the crux of the decision. I think the takeaways from this decision are still to be determined. There's a lot here that will be unpacked going forward by future court decisions and by agencies. One question is, what is a common law cause of action? This court said securities fraud equals common law fraud. You know, what of the FCC, for example, that it regulates is considered a common law cause of action. The FCC is doing a lot in its enforcement bureau in the area of privacy and security. There are a lot of common law privacy torts. So does a cause of action that the FCC might bring for a CP&I violation equate to a common law cause of action for privacy, like an intrusion upon seclusion, sort of traditional privacy torts? I think another big question is how big, or perhaps how small, after the Chief Justice's opinion, is the public rights exception? So again, looking at the FCC as an example, the spectrum of public right, such that spectrum enforcement decisions might be able to take advantage of this public rights exception and be adjudicated by the FCC. Broadcasters are supposed to operate their spectrum in the public interest. Is that a public right? Also would take broadcaster enforcement back under the FCC. There's also an interesting piece of the FCC statute that isn't present in the SEC statute at issue in Advocacy, and that is the jury trial right at the end of the process. So in the FCC, you can go through a forfeiture proceeding. There's an NAL, you oppose it. There's a forfeiture order, you choose not to pay it. DOJ can come and sue you to collect. Is that enough of a jury trial right to save that whole structure? Probably not, but still to be determined. And remember also that a big difference between the SEC and what we see at the FCC. The SEC has an option in its statute. It can go to court, or it can go to the ALJ. The FCC has no such option. So if the ALJ is unconstitutional and all or part of the FCC's enforcement action, the FCC really has a problem on enforcement.
Yeah, I mean, I will get into non-delegation, but I sort of more broadly want to talk about the Banquo's ghost that's here at the feast, which is this whole question, as was alluded to, of constitutionality and rearranging the relationship between government. Advocacy represents one other because the court mentions tariffing as being one of the traditional exceptions. Tariffing traditionally included more than simply rate setting. It determined the conduct of the common carrier. How broad is the tariffing exception? Does CP&I, for example, fall within the traditional common carrier obligation of privacy of communications, which might fall within that tariffing or it might not? But let me start with non-delegation, because as we heard very clearly this morning, and, you know, as was alluded to over here, a lot of this is flowing from, with varying degrees of self-righteousness, if you read the opinions, this idea that bureaucrats have usurped the role of Congress and democracy, or alternatively of judges. The most clear example of this was the Fifth Circuit's en banc case in Consumers Research versus FCC, the USF case, where the majority opinion, the language is quite stunning. I mean, it goes into second person and is a screed about restoring democracy, and what it found to be the non-delegation principle was that Congress did not set a precise amount. And this is where the 7-judge dissent, and every other court has dissented, that Congress told the FCC very clearly what it wanted to have happen. You know, it gave it broad general principles that have been accepted, but to the majority, the fact that Congress doesn't quarterly say you can raise this much means that there isn't a sufficient principle. It then goes on with the question of, well, how much can you use a private entity? Courts had traditionally found that, well, the FCC maintains control over the USAC, which administers most of the Universal Service Fund, because it's forbidden from doing policy. It keeps the intrinsically government functions within the FCC. Again, you know, the Fifth Circuit found that was not the case. again, largely because it was USAC that set the contribution factor, so the amount of money had to be that specific for it to not violate non-delegation. But we see these questions surfacing. So non-delegation or separation of powers is not referenced in Loper-Bright directly, but it talks a lot about how judges and the business of judging, of the interpreting statutes, is intrinsically to the judiciary. And you can read that as being about expertise, or you can read that as being a constitutional separation of powers issue. And in that process, you can determine how much Congress can make a course correction. I mean, again, we heard this morning, 2 FTC commissioners said, well, no, Congress can't, do a course correction on delegation that would allow you to have this sort of broad, future-looking, we have a general problem, we want you to go out and fix it. That is a violation of non-delegation, as opposed to, and where Congress says, yet defer, that should be interpreted in a fairly narrow way. Major question doctrine, there's actually dueling concurrences between Gorsuch and Barrett, where you read Gorsuch and you see that this major question doctrine is rooted in non-delegation, that Congress has to say explicitly because that is about delegation. Whereas Barrett, it goes out of her way to say this is not about delegation. This is simply a tool of statutory interpretation, and we should reject the entire idea that this is about non-delegation. This leads to confusion among the courts as to how you operate this. The Sixth Circuit said, well, in the FCC case, well, we don't have to reach best interpretation of the statute because we're just going to decide major question. And the Fifth Circuit reversed a district court which had used similar logic and said, no, you only get to major question doctrine after you have tried to determine the best meaning of the statute, and then this is a tool for how you break a tie in an ambiguous situation. So we have a lot of these sort of constitutional questions which are animating all of this, which is going to make this very, very difficult and complicated. And while the debates on these things may have been, as was asserted this morning, a process of 20, 15 years, the actual culmination of this has been incredibly quick. I mean, we have seen administrative law, everything I learned in administrative law is now thrown into doubt. And I don't think I'm alone in that, and I think administrative law professors are scratching their heads as to how they teach this in class. So I don't know how I would advise members of Congress. I don't know how I advise agencies at this point. I don't know how I figure out what it is reasonable for me to advocate for, because I have a big principle that you don't advocate for things that it's impossible, that it's illegal for an agency to give to you. So we have very confusing times ahead of us, and part of that stems from this deep belief on the part of some that this is core constitutional non-delegation going, Schachter Poultry was right and everything else since then has been wrong, versus a sort of lighter view of non-delegation where, no, if Congress just says it more explicitly and more clearly what its intent is, that is sufficient.
Great. Well, thank you all for your first thoughts. There's so much to unpack. I just had a general question for you all. How much of all of this discussion is heightened by how technical these topics are now? So since the 70s, we've seen technology grow, the Federal Register grow. There's just more volume and more expertise for each of the three bodies to handle. How much of it is just time that has passed, like 30 years of technological growth, and how much of it is constitutional?
See, this is where it gets really weird, because does the FCC's decision to rely on Monte Carlo probabilistic determinations of harmful interference, switching from its traditional model, a decision which impacts billions of dollars in economic activity, is that rising to the nature of a major question, or is that routine? Is it a major question, but it's clear Congress intended the FCC to do that? It seems that the answer is, if my eyes glaze over as a judge, then it's technical and I let the agency decide. If by, quote, reading the Wall Street Journal, I feel I know better, then I get to do whatever the heck I want now, officially. And it's, I think, some of this is motivated by a story of constitutional usurpation, which you see in a lot of the language of the decision, but some of this just seems to be motivated in, a question of whether a panel of judges thinks, yeah, I could do that. I could decide that.
I think a lot of that actually, though, falls into like State Farm analysis and arbitrary and capricious analysis. And if you buy the notion that technology is making all of this stuff harder, then maybe as a judge you need to be more deferential to that kind of nuts and bolts expert analysis. That doesn't necessarily translate to reading texts. So going back to, say, the MCI telecom case, so that's already all the way back in '94, what does the word modify mean? And so Justice Scalia looks at that and says, well, you wouldn't say that the French Revolution modified the status of aristocrats in 18th century France. And the scope of that word is, something judges have something to say about. It's a weird decision when you look into it, because he then goes and says, well, the FCC, by wanting to get rid of tariffing on a big part of the industry, and he says, what is it, like 40% of the industry? Okay, well, we don't think Congress would have said that that's what modify means. So it's this mixed question, right? He's kind of doing what Harold might say, reading the Wall Street Journal and forming an opinion, but he's also, making a textual analysis of what the word modify means. So I think it kind of depends on which side of the telescope you're looking through on that one.
Also, Loper-Bright has these safety valves that respect the predicament of judges in complicated ad law cases. So if you have an expert agency that has a particular view on how to apply terms like reasonable or non-discriminatory, Loper-Bright permits judges under one doctrinal formulation or another, whether it's Skidmore or express delegations or implicit delegations through abstract terms like reasonable or appropriate. Loper-Bright permits judges to, in effect, defer to the judgment of agencies as long as they're not contradicting the statutory scheme and as long as they're engaged in reasoned decision-making. Again, though, I think that Loper-Bright does reflect sort of an attitudinal shift on the part of courts. I think courts are now directed to try harder than before to impose their own interpretation of statutory provisions. And that's going to have consequences in some cases. I'd also like to just mention one other thing about a central irony of Loper-Bright. The court pretended that by overruling Chevron, it was creating more certainty, and that from this point on, we will restore the appropriate boundaries between the branches of government. Courts will go on doing what courts should be doing and what they do in other contexts. And the Chevron was this unstable anomaly. I think that the Loper-Bright formulation, as well as the major questions doctrine, and for that matter, Jarkissi, and the non-delegation doctrine to the extent it gets reinvigorated, they all rest on very unstable distinctions. Like, is something rooted in the common law or not? Is something a major question or not? Is something ambiguous? Or, I'm sorry, is an agency is an agency acting pursuant to an implicit congressional delegation of authority or not? Those are all difficult distinctions. And I think what we'll see in the next 10, 15 years is an attempt to give greater content to those distinctions, I'm not sure that effort will be successful. I think that, in some of these cases, these new doctrines may go to the way of the Supreme Court's recalcitrance in the face of New Deal legislation, which also rested on unstable distinctions between, for example, what is in interstate commerce and what's not. At some point, the courts are going to have to give greater deterministic content to the distinctions that they're beginning to draw in these areas.
There's a controversy right now that I think perfectly explicates this point, which is the debate between the FCC Chair Rosenworcel and Brendan Carr over whether you can require broadcasters to identify the use of artificial intelligence in political advertising. The Rosenworcel view is, for 90 years, the FCC has had clear authority from Congress to regulate the conduct of broadcasters, including mandatory behaviors such as keeping a political file or making these kinds of necessary announcements. And this is just continuing in the tradition that has been recognized as delegated to us. Carr is, well, no, artificial intelligence is something new. It's a new technology. It's a new thing. And unless the FCC, unless Congress explicitly amends the Communications Act to give us authority to address the use of artificial intelligence in political advertising, then we are prohibited by Loper Bright because the statute should be read restrictively. That's not me putting words in their mouth. That was literally the fight they had at a congressional oversight hearing, and I mean fight, as in shouting at each other. And you can read the current decisions either way. I mean, it's not at all clear, other than the fact that I'm pretty sure that if we landed in the First Circuit or the D.C. Circuit, Rosenworcel's view would win, and if I land in the Fifth Circuit, or the Eighth Circuit, then Carr's view will win. And that certainly does not increase, as John was pointing out, that doesn't exactly increase certainty.
Just a follow-up question that I have for you all. What are your intuitions on the role of Congress here? So this panel is really a separation of powers panel. Can Congress get that specific? And this is following this morning's discussion as well. For some points where a whole industry could change based on a definition, you would think that you want Congress to weigh in, but what is your view of what Congress can do, what they should do?
Well, I mean, we have to be informed by realpolitik here, which is that Congress has become less good at its job than maybe it was at the time of the founding. And this goes back to what I said earlier about a pendulum swinging in the judiciary between pragmatism and formalism. And Chevron was an intensely pragmatic doctrine in that it said when Congress leaves ambiguities in statutes, it intends for the executive branch to resolve those ambiguities. And so that was, whether you think it produced good outcomes or not, that was a deeply pragmatic approach to a problem of government. The Supreme Court concluded that went too far, and it's very wedded to, this current Supreme Court is very wedded to very formalistic principles of separation of powers. And that's what's animating a lot of these decisions. And sometimes that formalism goes too far in that it ignores the political problem that Congress can't really be expected to legislate in fast evolving areas and with great specificity every few years and to do the right thing. It simply won't happen. And in a country that's facing a lot of technological change, a lot of pressing societal problems, it's problematic to be too formalistic.
And I'll add, look, this is where the question of how much of this is animated by constitutional concerns becomes critical. Because if this is just statutory interpretation, then you could amend the Administrative Procedure Act tomorrow and say, when a court is reviewing a decision by an agency with regard to the interpretation of a statute, that court shall defer to the agency's interpretation. Standard, setting of what is the level of review. If this is because Article 3 gives reading statutes, interpreting statutes to judges, that's unconstitutional. If it's just a question of, if Congress decides, where it wants this, what level of review to set by statute, as it does sometimes in various other statutes, then it's fine. And we just don't know right now which way that comes out.
Yeah, I think it's an incredibly complex question, but there has to be some balance between making sure that Congress has the ability to set, sort of as Justice Kagan said in the West Virginia dissent, broad objectives within which agencies can meet new problems versus this sort of set it and forget it. Congress passed a law that involved in the environment one time, and it was 100 years ago, and now, at some point, Congress needs to address new problems. And it's incredibly difficult. To just make this a little more concrete, let's take the SEC and the crypto litigation and the climate disclosure rules. And I'm gonna just put these out as positions that I don't necessarily endorse or dislike, but let's say, like crypto, the SEC is supposed to figure out what a security is. Okay, so crypto's this new technology, but does it walk like a duck? Does it quack like a duck? Like, are people investing in it looking for a return? So, maybe the crypto industry has an uphill battle there. Why do people invest in securities? Well, they're looking for a return, or at least that's how the securities law understands investors. So does the SEC get to now impose sort of side goals because Larry Fink decides that the climate is important? And so now it's a climate regulator, and it's doing climate disclosures in the securities that, bear in mind, a company already has to disclose a material risk based on climate change as it is. So what are these new rules doing if they're not sort of taking the SEC and transforming it into a regulator that's doing something fundamentally different? So I just set those out as stakes to try and give us an image in our head of like, where do we find this line between, Congress needs to do its job versus Congress did its job, like courts stay out, let the agencies adjust to new circumstances.
Section 254 and the non-delegation cases will be a good test case for this idea. Section 254 has been around for decades. Universal service has been around long before that. The statute has been tested. It's been challenged on appeal. FCC decisions interpreting it have been reversed as going too far. Congress has amended it, and it's still there, and now suddenly the Fifth Circuit says it's unconstitutional. If the Fifth Circuit's decision stands unchallenged, or the Supreme Court affirms, then the question will be put to Congress in a very emergency, very real way. If suddenly the FCC can't collect contributions for any of its 4 USF programs and maybe other programs that are relying on that. You heard the prior panel express some reluctance to moving to an appropriations model. That means they have to write a new universal service statute. Can they write something more direct than Section 254 that's still functional, as Corbin and John were talking about? I think that's going to be quite the challenge.
Great. I have one more question. Oh, and then I'll go to Alan. How much of this is influenced also by trust in institutions? So, the Supreme Court is getting a lot of skepticism. It's politicalized. People read the Wall Street Journal. They think, law Twitter. They think they know admin law and Chevron. How much of this is about restoring, trust in our institutions? If Congress decides something, if the judges decide something, if agencies, and then people don't trust what they're deciding.
I'll dive right in, because this goes to my point that the courts need to be careful even if you agree with what they're doing, because we have 3 branches, and at the end of the day, one of them cannot rescue the others from themselves, and especially the judiciary. I'm a big believer in the Alexander Bickel view that they are the least dangerous branch, and if they don't heed that lesson, they will eventually discover it. And so, you know, even if the judges are on this righteous crusade, they don't have control of, you know, Harold mentioned the Wall Street Journal, but they don't control the New York Times or the Washington Post. And people are going to form attitudes about them that are not in their control. And to use John's point of realpolitik, I think they need to be very aware of the fact that they can set boundaries, they can fight for the separation of powers as they see it. But if they take that too far, they will discover the limits of their power very quickly.
Well, I just have to say, reading the language of some of these opinions, first of all, I just cannot help but laugh at the time spent in Loper Bright rehabilitating Scalia to be a doubter of Chevron. I mean, it's almost religious in its, you know.
Hagiography is.
Yeah, but it does illustrate the extent to which we have a lot of judges here who see themselves, and writing quite explicitly that they see themselves as protecting private industry from, you know, an unaccountable bureaucracy. We see this in the jawboning cases, and, you know, we see this in, you know, in a lot of the regulatory cases, which often ignores the fact that you're picking between winners and losers in, even if you see this as being just about protecting industry, you're picking winners and losers in industry. And I think that, you know, this is very driven by a lot of folks who bought into public choice theory, who just don't like the deep state, even if they don't call it that, but who really believe that that's what's going on here. And, you know, I won't say there's no justification for that in terms of administrative law, but the fact is that there is a real belief by a whole lot of judges that their job is to hold agencies, although not the executive, in check, and that distrust fuels a lot of what goes on here. And as long as that continues, I'm not sure that we get stable law.
Harold's point, I think, I want to take issue with bureaucrats. Not with bureaucrats as people, but as the concept. So in the Chevron era, that is to say the Reagan administration, there was the notion that elections had consequences, and that to the extent that it was not precluded by law, the president's policy agenda ought to drive regulatory actions, right? So presidentially appointed cabinet secretaries, or perhaps independent agency heads, would control regulations that were then the responsibility of presidentially appointed assistant secretaries and presidentially appointed deputy assistant secretaries, and that when the regulations were drafted, they would go over to the Office of Management and Budget, where the Office of Information and Regulatory Affairs would ride herd on the agencies to conform their regulations to the president's policy agenda. So now we call them, you know, bureaucrats, we call them the deep state, but the fact of the matter is that these are, and it should be in the concept in Chevron, and when Scalia was in favor of it, he would have viewed it this way, they're agents of the president, right, who's politically accountable to the people more so than obviously than the judges are. So while I take some exception to my esteemed partner John Nuechterlein's comment that Chevron was pragmatic, I think that they intended it to be principled, which is to say that non-accountable judges shouldn't be making policy decisions when the president should be in charge of policy. So how have we gotten so far afield of looking at regulations as the product of bureaucrats, or the deep state, if you will, rather than of the president and his or her presidentially appointed agents, and with OMB kind of trying to enforce the president's policy agenda?
Well, remember that the current Supreme Court believes, and they say this without any irony, in Loper Bright that it is Congress's job to decide important matters of policy, and the executive branch should merely enforce Congress's policy choices, not make policy on its own, except in the interstices to the extent Congress wants it to. So that is a very unpragmatic and highly formalistic view of the separation of powers, which is hard to square with the demands of the modern world. I'd also like to make one other point, which is sort of related to this, which is to the extent a lot of this is motivated by animus towards government and people who work in government, if you defang the federal government, it's not like regulation goes away. You create a vacuum into which the states will fill. And we already see that in a variety of areas. And contrary to what Commissioner Ferguson said this morning, I think we're much better off in a global world today where you have the federal government, or one decision maker, making decisions, whether they're pro-regulatory or deregulatory, on matters like AI or internet policy that inherently transcend geographic boundaries. So I'm a little nervous about taking the defanging of the federal government too far, in part because I think you're going to get a hodgepodge of highly regulatory state responses to that.
Great. Well, on that note, thank you so much to our panelists, and we'll go to our next topic. Thank you.
I think Laura, oh, there you are. Laura, you're up.